Hi, my name is Blake Rogers, and the case that I am doing covers the contributory and comparative negligence. The case title and citation is here, Yee versus Yellow Cab. This occurred in 1975. Some of the basic facts of the case. So, it was just a traffic accident between defendant Yellow Cab and plaintiff Lee. Lee was making a left-hand turn and in California, and when she made the left-hand turn, the driver of the yellow cab company car was coming over a hill and ran a yellow light and was speeding. The plaintiff Lee was negligent because she made a left-hand turn when she shouldn't have, and obviously the defendant was negligent when he ran the yellow light and was speeding. Initially, the trial court held that the plaintiff was barred from recovery by her own contributory negligence. The main issue here is, should the affirmative defense give way to a system of comparative negligence, which assesses liability in direct proportion to fault? The court's decision, so the court reversed, saying that this was a pure form of comparative negligence, should be adopted in place of the contributory negligence doctrine. Thus, even though the plaintiff contributed toward the accident, the defendant was also liable for his portion of the fault. Under the doctrine of comparative negligence, liability is based on relative percentage each party's fault if both parties are negligent. So in this case, both parties are negligent, so the court must decide on a percentage basis how the damages will be, or how the fault will be distributed. As a matter of public policy, the doctrine of comparative negligence is preferable to an all or nothing rule. From the point of view of logic, it just simply makes sense that if two people are at fault, then you base it on how much they were at fault. You can't just blame one or the other just to have a winner and a loser. The case is unique because its reasoning regarding the section 1714 of the Civil Code, which had been thought to codify the all or nothing approach of the contributory negligence. While the plain meaning, just on paper, section 117 was quite clear, the court decided that the legislator had not meant to stop the process of common law evolution, which is quite normal in state tort law, but rather simply to clarify law as it then existed. So they just wanted to clarify why it was changing, and it just made logical sense to initiate this. Some of the opinions of the justices: Clark, he dissented for over a century. This court, and this is his words, for over a century, this court has consistently and unanimously held that the Civil Code, section 1714, codifies the defense. Now, after 103 years, the court declares 1714 shall provide for comparative negligence instead. So, in his view, he thought this action constitutes a gross departure from established judicial reviews and rules and rule. Mosk, on the other hand, he concurred in the judgment and agreed with the substance of the majority opinion. He dissents from its cavalier treatment of the recurring problem in the manner by applying a new court-made rule. That concludes this